Good evening and welcome. Welcome to That's the Law. I'm B.J. Krintzman. I'm an attorney in Newton, and now I have to add I'm also an arbitrator and a mediator because I've basically given up client-based practice and am serving only as an arbitrator and mediator. And we're going to touch on the topic of arbitration and mediation a little bit tonight, but our topic is divorce and tips from a divorce attorney. There is a better way. And you're going to hear all about that because we have the expert with us. Join me in welcoming Vicki Shemin. Vicki, welcome.
Thank you, BJ. Honored to be here. Thank you.
Nice to have you here. We only met this summer, but I just knew she was going to be a terrific guest because she's a terrific attorney. So that's about all it takes. And by the way, she's not only an attorney, but she's also a licensed social worker. So she is uniquely suited to help people not only get divorced, but also to help them with the psychodynamics involved in getting a divorce. So Vicki, I'm so glad you're here because I really want to talk about that stuff. So welcome again.
Thank you.
And when I asked you what you wanted to talk about, the first thing you said was, well, there is a better way to get divorced, and that's what you wanted to talk about. And you wanted to talk about options. So we'll begin there with the options that people have when they're getting divorced. So there's, of course, the traditional way, which is?
So typically, what I've found in the last 35, 40 years of practice, I know I don't look that old, is you call an attorney and they say, okay, well, I'm happy to take your case. I need a $15,000, $20,000, $25,000 retainer. We're going to file and we're going to get you everything you want. In my estimation, attorneys are really obligated to lay out all the alternatives that you can have. And we put that under the umbrella of alternative dispute resolution. So the attorney really should be introducing you to a panoply of options, which will be things like mediation, conciliation, collaborative law, cooperative law, and then there are all different nuances under that. Arbitration, that you're an expert at.
Right. And also mediation. I do mediation as well. I think it's important, we want to point out that even if you go one of these alternate routes, you still need an attorney.
Absolutely.
Right? So the divorcing couple can hire a mediator, and a mediator doesn't decide anything, that's just a negotiator. Let's see if we can get these two people to yes. But regardless, when push comes to shove, you have to bring any separation agreement you came up with in front of a judge.
Right.
Right. So, and similarly with the other alternatives, correct?
Right. And I don't mean for them to sound mutually exclusive, because sometimes there are reasons to actually file. But I would like folks out there who are in the divorce situation to contemplate maybe parallel tracks so that you're not on an all-out path toward Armageddon. Save the money for your children or for your family, for yourselves, and see if you need to file because you want to, what we call, toll the length of the marriage for alimony payment reasons or other reasons, you can still adopt one of these parallel tracks. So you can file, stop the length of the marriage, and go on a mediation with an unbiased person who's going to help facilitate those conversations.
Right. And another reason that you might want to file, even if you're going to try to negotiate it, is not just to determine what the length of the marriage was, but it's also because when one files, in Massachusetts anyway, an automatic restraining order on assets. This is not a restraining order that says you can't come in the house. This is a restraining order on assets goes into place. So that's another reason, particularly if you don't trust the spouse and you think they're going to be hiding money in the offshore account.
Yeah. So that's an excellent point and a very important point. What I've done in many situations, if somebody doesn't actually want to file because of that increased retainer or because it just sets a tone, an adversarial tone, it's, Joan versus David or David versus Joan versus what we hope to be a Joan and David asking the judge for a divorce. So even though there's not an automatic restraining order, we've entered into what I call interim agreements, where we set forth a number of understandings, including an automatic restraining order. Nobody's going to be changing wills or insurance policies. And then the last line of it is either party can request that the court enter this as a temporary order. So it has a little bit of force to it,
Right.
Although it's not as airtight
Right.
as actually filing.
Right, excellent. And I think also what I've done, because part of my practice was divorce, was during the first meeting I would discuss these alternatives. I truly did discuss the alternatives with the whoever had come to see me. But the other thing was that then they would say, well, what should I do? Should I just file or whatever else? I said, could you possibly discuss it with the other side? Tell them you've seen an attorney. Tell them you're going to be filing. What's the best way? So even that part becomes a little cooperative, and not because I can't imagine just being served with papers when you don't know that that's happening, and that also just sets the wrong tone
Absolutely.
for trying to negotiate a settlement.
I wish I could tell you the number of times that somebody's been served at work, which is the height of embarrassment,
Yep.
or a sheriff or constable will, in a very official-looking car, will pull up and a child answers the door, and you're totally blindsided. So yeah, that is not the best way. And one thing I always talk to my clients about is who's the attorney on the other side, because that is one of the biggest factors, I think, in how your case is going to go, right?
Absolutely.
And
Absolutely.
if you don't know who that individual is because you haven't worked with them, pick up the phone. I pick up the phone, I make a call, introduce myself,
Yep.
say, David is hoping that this can be an amicable, cost-effective divorce. I hope Joan feels the same way.
Right.
What can we do as to kind of be on the same page to help them effectuate that?
Right. Now, there are situations where mediation is not a good idea. Do you want to discuss some of those?
Well, this is actually very interesting and a little bit controversial. So there are some mediators where there's been intimate partner violence or domestic violence who would never do a mediated case. But there is some success out there where you can have what we call shuttle diplomacy. What we call party, each divorcing individual is in a different room. And so it may not be wise at all. They may not be comfortable, or they may not even be allowed under the law because there's a restraining order just to be in the same room with each other. But the mediator can go back and forth between the rooms.
Right.
So that's one instance, but another distinct one is if you just don't trust the other person.
Right. Right. Well, yeah, I think that the notion, the power imbalance, which is automatically there if there's been domestic abuse, but the power imbalance, where I'll say she, okay, where she's afraid of him and she's afraid to speak up and she's afraid of the mediation, this isn't going to work. And what I do is I assess my client and see, would she be suitable for mediation? And if I see that she's frightened, I will tell her not to.
Yep.
And also, if you're doing the shuttle diplomacy, as we call it, if you have your lawyer with you, that's okay. I feel much more comfortable
Yes.
with certain clients
Yes.
if that's how it's happening. The other thing, other than just the power imbalance, as you were getting at, I think, is if you don't trust the other side, which is this them, the opposing spouse, just fishing to find out what your final negotiation posture is going to be. And if they just want to get information with no real intention of settling it, but just now I have more ammunition I can use in court.
Gotcha.
By the way, you can't, mediation is confidential, so that you can't use what the other side says and then say, well, the judge in mediation, she said this or that.
Right.
But I'm talking about that the party would know,
Right.
how they're feeling about it.
Yeah.
And do you do mostly mediation of divorces? Is that what your practice is?
I do a great deal of mediation with this social work background, and because I have a special interest for some reason in working with high conflict families. I do a lot of what's called parenting coordination, which is, again, a neutral who can be appointed by the court or who the parties can privately hire at any point before, during, or after the divorce to help them with decisions regarding the children. So for some families, it's where are these kids going to spend Thanksgiving and Christmas, and when does Thanksgiving start? Is it the Wednesday night before? Is it the Sunday after? And because you're going to co-parent with this individual for the next 15, 18 years, is Susie going to take ballet? Is she going to take basketball? What if you don't agree on tutoring? What if one of you thinks she should go to private school and the other one doesn't? So there's a myriad of decisions that as you sit before the judge, you can't even imagine are going to come up. So it's very helpful to have somebody called a parenting coordinator. And most of my clients, when I'm a parenting coordinator, actually empower me to make the binding determination if they can't decide.
Oh, right. And exactly. You know, in my, 30 years of practice, and I had hundreds and hundreds of divorces, I maybe had a handful that used a parenting coordinator,
Really?
and probably more towards the end. And I kind of considered it like a failure in a way that I couldn't get the parents to agree when it came to the kids of what had to happen. I also think it's very important, and I would tell me what you think of this, but I would have a client and I would say, well, let's talk about Christmas and let's talk about New Year's and who has them on Hanukkah and who has them on Mother's Day and who has them on their birthday and blah, 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 blah. And they would say, well, don't worry, we can work that out.
Right.
Well, sometimes they can, but what I felt was it's better for them to have it in black and white, because then there isn't a fight about it and things don't change. And also the kid, what you don't want is the kid to decide, say, well, do you want to be with mommy or daddy?
Of course.
Right? That's the worst. So I said, this actually, by putting it, it says, then everyone just says, well, that's what it says in the agreement. So that's what we have to do.
Right.
And it takes the burden off the child. Do you feel that way?
Absolutely. So it can be a default. You can choose not to use it. But in case you don't agree in any given year, you can use it. I can't tell you how important I feel it is and how helpful so many people have felt. And if I have a client who's waffling, I might say, come on a journey of a thought experiment with me, and let me ask you to imagine 3, 5, 7, 10 years from now, and it's your child's college graduation or high school graduation. How do you want your child to be able to feel? Do you want your child to be able to be sitting at a table celebrating with both of you? Would you like to be able to get your relationship to that point? Because right now you've just been through months and months or years and years of an adversarial system, which does nothing to basically promote that healthy co-parenting relationship that you want at the end for the sake of your children.
Right. Oh, that's that's wonderful. And what I used to say, there's an old African expression: when two elephants fight, it's the grass that suffers.
I love that.
And that stops everybody in their tracks because they know exactly what they're. And the mental picture I have is of the mother and father, tugging on the arms of a little child.
Yeah.
Just you touched upon collaborative law and conciliation. Do you want to flesh those out a little bit? What those options are?
Yeah. So conciliation is one of my favorite things because you are hiring either a retired judge or a very seasoned family law attorney. So somebody like you who has been in the court system and knows what the sitting judges are likely to do and likely to think. And we would come to you with, who are my people, Joan and David, and say, look, attorney, conciliator, we have been spinning in circles, just spending money that we'd rather be able to save for our children. We've been able to agree on ABC, but we really need help with XYZ. And we present to you what those challenges are. And the difference between conciliation and mediation in my mind is that a conciliator bottom lines people. Say, people, you can argue about this for another 3, 4, 5 hours or 3, 4, 5 years, but I'm going to tell you what your judge is most likely to do.
Right.
And they tend to, I don't want to say force, persuade strongly individuals, whether by talking to them together, talking to their attorney separately, whatever, to really get them to have a meeting of the minds.
Right, and they often need to hear it. And I had no compunction about saying, no judge, excuse me, no judge is going to XYZ, whatever it was. And then that just settles everybody down. Okay.
You know, I like to be psychologically minded a little bit. One of the most important things for people is to be heard and to either literally or figuratively have their day in court.
Right.
And one of the beautiful things about a conciliator is you can tell your story.
Yeah.
And it's probably going to be a combination of something emotional and something legal. Right. And you often just need to be able to move past things by having somebody hear you. And your conciliator is going to be able to give you a lot more time than a judge will, who has a courtroom full of 50 people, impatient people waiting, and can give you about 3 to 5 minutes.
Collaborative law.
Collaborative law.
And I've done shows on collaborative law, but just why don't you bottom line it what it is?
Okay. So there's what I call the orthodox and the less orthodox collaborative law. The orthodox is where you come to the table with the parties, come to the table with their attorneys, sometimes with a financial neutral, sometimes with a parenting coach, and you sit around the table, and virtually all the meetings take place with that team. So people who don't have a voice because of a power imbalance or some other reason have the comfort of their attorney near them. Now, the orthodox one says that if you can't work it out in the collaborative law model, then your attorneys are going to have to be basically fired. None of the what's called discovery that you used can be used ever again. You've got to start all over again with new attorneys. And I think that's a little strict.
Well, you actually sign a collaborative law agreement, and
Right.
the attorney signs saying, if this case goes to court, if it doesn't settle, I step back.
Right.
I'm not allowed to go to court. And
Yeah.
that's the traditional, really serious way. And what it's supposed to do is put everyone in the mindset of,
Yeah.
They don't want to give up their lawyer, the lawyer doesn't want to give up the case, so
Yeah.
it's going to get settled. So that's
So
sort of what it is.
kind of non-orthodox one is called cooperative law,
Right.
which basically has the same structure, except to say, you know what, if I don't mind if David keeps his agreement, and David doesn't mind if I keep my attorney, and
Right.
he doesn't mind if I keep mine, or we can still do that and not throw out all this discovery and everything we've worked for to date.
All right, so we're talking about a perfect world where we have all these options with wonderful attorneys. Now, how do you pick an attorney? How can people know what to look for and how to get the attorney they should have?
Okay. So I can't emphasize enough, this is one of the most important decisions because you are talking about some of the most precious things in your life, whether or not you have children, things that you have worked probably a lifetime for, your house, your retirement, your pension, all the other assets that you've worked very hard to accumulate. It's a relationship like anything else, and you've got to feel like you are understood, like you have confidence in your attorney, like your attorney understands you and your attorney is going to have time for you. I have had clients interview me, for which I'm grateful, asking me questions, firing questions away at me for half an hour, and I feel like I've just come out of a law school exam. I want to know exactly this, I want to know exactly that, and I encourage them to do that. And not only that, I encourage them to maybe interview 2 or 3 other lawyers to make sure we're a good fit. Among the questions I would ask is, are you going to be working on my case, or are you going to walk down the hall to your associate and say, okay, work with
Right.
Joan and David now. How are you going to bill me? Am I going to get a bill once a month? Is my bill going to itemize everything you've done for me? Are you going to bill me in tenths of an hour or quarter of an hour? That makes a big billing difference.
Right, and by the way, I just want to point out something there. Without thinking it through, you think, tenths of an hour is worse because they're charging for everything. Tenths of an hour is better because if it's a 4-minute phone call and the minimum is a quarter of an hour, you're going to be billed for 15 minutes. So you got to think that through. I billed in tenths of an hour.
Right,
so,
right.
Yeah.
And you know, if I send you an email, when can I expect to hear back? Do you have a 24, 36, 48-hour rule? If I can't track you down, do you have a paralegal? For a lot of the work that needs to be done, can I be a partner with you? Like, I hear that these things called financial statements. Well, I'm pretty organized. Can I partner with you to get the first draft of my financial statement to you? Or do you have a paralegal who bills at a lower rate that could help me? So
right, and you also might ask, do I get billed for both of you when you and the paralegal are talking to each other?
Absolutely.
Because then instead of it being $600 an hour plus $200 an hour, now you're paying $800 an hour.
Yep, yep. When you have to travel to court, are you billing me for the full rate? And when you're sitting there all day in court because there's 20 cases ahead of us, no kidding, how are you billing me? So there's a lot of questions to ask.
Okay. And is there any way you can do any research on attorneys to find out if, you know, does it help to talk to people who've hired that attorney in the past, or checking with the Board of Bar Overseers to see if there are complaints about this attorney?
Yes, the Board of Bar Overseers is the regulatory structure, and anybody can at any time look up an attorney and see if there's been any disciplinary complaints filed against them. You can, you know, with the Google world and social media world today, you can find out a lot about an attorney. We all know somebody, unfortunately, who's been divorced, asking friends and family members for recommendations. But at the end of the day, it's your gut about what you feel comfortable with.
Yeah, I have to feel good about them. And there should be a client fee agreement, correct?
Oh,
in writing?
Absolutely.
Okay, and what should be in the client fee agreement?
The client fee agreement, as 30,000-foot view, sets forth the firm's responsibilities to you and your responsibilities to the firm. So it covers exactly what scope of services is. Like, I tend not to go to court except if it's on a uncontested matter. So I have to spell that out very carefully so people don't assume that they're going to be paying for a court appearance for me. Also talks about, well, if you want to dispute the bill, which of course you should feel very free to ask questions, please do so within 30 days. And if we don't have a meeting of the minds about what should happen with anything that you might be questioning on the bill, we'll agree to go to arbitration. So it sets forth those kinds of things. The best way to contact me, you know, my email.
What about how long the rate quoted is in effect?
Absolutely.
Do you does the lawyer have the right to raise the rates if the
Right.
matter keeps going on?
Some of them say every January 1 we review our rates. Some say we'll keep this rate in effect for the duration of the case. So those are all very important points.
Right. And the other thing is, for people hiring an attorney, when you get the client fee agreement, it should say in it, and your attorney should, the prospective attorney should tell you, you have the right to consult with another attorney to review that client fee agreement.
Absolutely.
Right, to see if...
This is, that bottom line, this is a legal document.
Right.
It carries a lot of force, so please do ask any questions or have another attorney look at it.
Do you have, like, your document retention agreement in that agreement? You know, how long
Yes.
you're going to keep their documents? Or
Yes.
Tell us about that.
It says that we will keep your document. I think it's 7 years that we are required to keep the document, so it says that. And just, again, all the responsibilities that the firm has to you. And, you know, if the relationship doesn't work out and you want your files transferred to another attorney, you know, we say, what can we do to make that process easier for you?
Right. Did I mention that you're with Fields and Dennis? I don't know if I mentioned that at the beginning. She's an attorney with Fields and Dennis. They're in Wellesley.
Yes.
But they have clients all across the state.
That's right.
Right. Okay. And are there other practice areas in Fields and Dennis?
One of the great things I love about Fields and Dennis is, you know, you often may want to do your estate plan when it's done. There could be real estate transactions. You may want an expert on taxes because of the tax implications of various things. So we have a pretty much full service ability to offer full services to clients.
Now, one of the first things I discussed when clients came in, but it's now become the last thing we're discussing today, but is the children of divorce. And what's the best way to involve the children in understanding about the divorce, and what's the best way to not involve them? And you as a licensed social worker deal with those psychodynamic aspects, so I'd like to hear about that.
Yeah. Maybe the best way to involve them is not to involve them. It's so important to keep in mind that you know, when children are, if you say something negative, derogatory about a child's father and mother, that's 50% of them, and they internalize that, and they're so precocious, and they've got little ears everywhere.
Right.
And you don't want them to grow up with that split loyalty. You have to recognize that you are imprinting a model for the kind of mate that they're going to choose one day. So I urge clients to have like a script, by which I mean come together on what you're going to tell the children, when you're going to tell the children, and what you're going to say to the children.
Together.
Together, ideally together.
Yep.
Yes. Answer any questions. Make sure they know it has nothing to do with them. And any decisions that are going to be made on their behalf are mommy and daddy decisions, and that they never have to be in the middle, and that we love them both, even
Right.
though.
I'm sorry. And also, don't play mommy off of daddy, because the kids are very good at that.
Very good at that.
And particularly
That's
if
part of
they're
their job.
Yeah, right. Particularly divorce. And you had mentioned before we came on about alerting teachers, guidance counselors.
Yeah. I think, you know, I don't think it's an over-exaggeration to say that this is one of the most difficult periods of anybody's life. I pretty much think that everybody should consider having therapy. When you talk to your friends and family, there can become what I could call the Greek chorus. Of course, what a bum, you know, you're such a victim. And that's not what you need to hear. If you go to a therapist, somebody who can help you be more objective and neutral, that's so important. And don't forget the children. They could use the support too. So yes, alerting their teachers, guidance counselors, the principal to please, this is what's happening with our family. If you're noticing any changes in behavior or you think Johnny could use some extra support, please let me know. I'd like to have, you know, very open communications with you about that.
Wonderful. You know, I'm wondering if it's all kids want to do is be like everybody else when they're little kids and teenagers. And divorce had a stigma about it if your parents were divorced. But now it feels like 50% of the country is getting divorced. So, you know, that the stigma's a little bit gone, but that doesn't change the internal aspects of what the kid is feeling.
Absolutely. That's well said.
Yeah. Again, we've been talking with Vicki Shemin, and she's with Fields and Dennis, and this was a divorce attorney. I hope you got some tips from us. And thanks so much for coming on, and we will see you next time on That's the Law. Thank you, and good night.
Thank you, BJ.